Hello, we're here again with Mr. J. Chauhan, a lawyer in Richmond Hill, who's been in practice for over 40 years, retired deputy judge. He served as a judge for 24 years, and Mr. Chauhan is organizing a series of CPD lectures that he's delivering to legal professionals. Today, Mr. Chauhan, I was wondering if I can talk to you about the administration of a will. The first question is, or my main question is, how do you actually administer a will?
But if I can go back, Dima, I'm glad you asked the question, and we're going to be dealing with this administration of estate file today. But I want to tell the audience, actually, that includes our Angel Mentorship Group, that in the university when you went there, by admission course, what is taught usually is this is the Administration of Estates Act. This is the law and how the distribution takes place. But nobody directly tells you, Nima, what are the steps 1, 2, 3, 4, 5 that you need to go through to complete a file? And incidentally, this area of practice is done by very few lawyers, so I would like the members to know, and anybody who wants to attend our lectures to know, that the area of administration of estates makes very good income. The reason it does good income is because the gift from the trust or the will to the beneficiary is a windfall for the beneficiary. So the executor usually does not mind making a payment for the legal fees at your full rate. So I think that's a very lucrative area of law, and I would encourage members of our group and those who want to start their practices to focus on that particular issue of how to carry out the administration of estates. So I'm going to outline the steps that are taken, and the steps that are normally taken is that a person is deceased. So there is the funeral, the family then figures out where the will is usually stored, and in our case we keep the wills in the filing cabinet, where we take it out and show it to the I would say the executor. It is the lawyer's function, in my view, is the function of advising the executor. When there's a conflict between the executor and the beneficiary can appoint their own lawyers. But the duty of the executor is to carry out the so-called mandate or the outline of what is said in the will. So step 1, have a meeting with the client and go over the assets that the client is showing on a checklist. And if we do the full seminar, we'll present the entire checklist that you can use for the meeting with the client. So once you've assembled the assets, you prepare an application to the what used to be called surrogate court, but now is called the state court, and you present the application, which essentially is an application to be appointed as an executor. That's the function of the court. And you attach the original will with one affidavit of one of the 2 witnesses. And you can leave it with the court. You don't have to have a hearing unless the court thinks there is a dispute on the appointment of the executor, in which event there will be a hearing. Otherwise there is no hearing. But usually it takes about 4 weeks to 6 weeks for the judge to reach that file from the court office. They will sign it, seal it, and that gives the appointment to the executor to carry out the terms of the will. And then the lawyer helps the executor to then make an assembly of the assets. There may be shares, land, house, property, etc., which are to be distributed according to the terms of the will. So once you assemble the assets and you ask the client executor to open an account in the bank in the name of the trustee, in the name of the estate, then the bank knows how to open an account of a trustee. And then you assemble the assets there or transfer the property, and then what you do next is that you obtain from the beneficiary the receipt of the amount that you've given. And when that has been done, you create an account. The estate accounts are differently prepared than the accounts of a normal accounting system. And that is the way to prepare an estate account is to show on the top the assets in the estate. And the next one is the deduction from those assets of the disbursement that you made, including the cost of the funeral expense, including the cost of the lawyer, and is an agent involved for the sale of the property, his cost, and other costs, and then you have the net assets which are distributed after payment of taxes, of course, to the beneficiaries. And then you write out the checks, obtain the receipts from the beneficiaries, and then if there's a dispute on the distribution, then you would actually go to the court and have the account passed by the court, in the sense that the judge approves the legal fees and then says that, yes, he's passed the accounts and approved the accounting and the distribution that you made, and that's the end of the estate. In the event that you have the acceptance of the payments made from all the beneficiaries and there's no dispute, what you can do is to obtain a release from the beneficiaries. And when you do, more or less you have completed the estate, and your role as a lawyer advising the executor, and then you can report to the client as to what you've done. And that is basically in a nutshell how you process the estate file.
Excellent, Mr. Chauhan. Thank you very much. Very informative as usual.
Thank you.
Thank you.